So let's start. My name is Sarah Badzagalupi. I'm with the Chapman Law Group. Chapman Law Group is a law firm dedicated to healthcare defense. The other colleague that is going to speak to you, hopefully he'll log in soon. His name is Ronald Chapman Sr., and he is the owner and president of the law firm. He has 35 years experience, and he'll talk to you guys about fraud and abuse, but we'll start a little bit today with licensing matters. That's what I will be covering as I work in our regulatory and licensing division. So licensing matters concern your license to practice in the state of Florida. The regulatory entities that cover licensing are, let me share the screen here. All right, here we are. So we're going to talk a little bit about physician profiles. As a physician in the state of Florida, you will have a profile that is accessible to the public. It is important that you maintain that profile. You have 15 days to update it for any particular incident, whether that is an update on your credentials or your education, but also any claims for malpractice and negligence. It is important that you keep these updated because they also list your address. And I can't enforce enough the importance of that. If you get a letter from a regulatory entity like the Agency for Healthcare Administration or the Florida Department of Health, that's where they'll send it, and not updating your profile is not a good excuse. So make sure that you update those. These are the sections down below that you might be interested in, the Florida statutes that talk about physician profiles. So you want to make sure that you keep an eye on those.
Excuse me, Sarah.
Yes.
You are not in full presentation mode. Do you think you'd be able to do that so it's on, takes up the whole screen?
Let me see here.
If not, it's not, I don't think it's urgent. It just might be a little easier for people to see.
I'm not sure why it's not showing that. Let me try this again.
Now you're in full screen.
Yes, you get to see my face. Let's try this. Is that better?
Yes, perfect.
All right, so I'm sorry, guys, let's start over. Just as a reference, all the statutes and rules that I'll be mentioning today are in your materials, and we have a lot to go through, so we won't be covering every single slide, but it's there for your benefit to read at your leisure. Going back to the physician profiles, just make sure you update those. If something happens, that's where they'll send you notifications, including reminders to renew your license to practice. As I'm sure a lot of you know, the current licenses have been, deadline to renew have been extended to March 31st. That's good. Make sure you get your ducks in a row before that. It's kind of a rush to get everything put together before you submit your renewal. And I do want to touch on a couple of things about renewal, specifically what happens if you do not renew your license within the biennium period, and that is that your license will become delinquent. A delinquent license is an inactive license, which means that you will not be able to practice while on delinquent license. That address will be important, and those notices will be important if you do not remember when to renew. So make sure to keep an eye on that. Also, another thing that I would like to cover is that licenses will not remain in delinquent status forever. The Department of Health and the boards will eventually render your license null and void if you don't renew for 2 years after that delinquent status. And it's a lot harder to get your license reinstated if that happens. So it's always best to consider other options instead of letting your license expire. Good resources here are the actual websites for your specific board, whether it's the Florida Department of Health Board of Medicine or the Board of Osteopathic Medicine. Their links are down here and in your materials. They also list the Florida laws and rules and regulations that cover what you need to do. I'm not going to go over this, as I'm sure you know, the types of licenses, but I do want to cover some disqualifications. So there is a statute now that governs disqualifying offenses. You will not be able to obtain licensure if you fall under one of these categories. The board simply will not approve it. Doesn't matter how good you are. It's a bar. So the language is a little tricky, so I want to emphasize a few things. We're dealing with crimes, number one. So if you've been arrested for a crime that is a felony in any jurisdiction, that means in any state, you may fall under one of disqualifications. The crimes usually concern fraud and fraudulent practices, but also controlled substances and substance abuse issues. If you are convicted, but also if you pled guilty or no contest to one of these crimes, regardless of whether the case has been adjudicated or not, you are barred. And the most severe bar is up to 15 years. And 15 years is not from the time that the criminal case is over. It's 15 years from the time that you have completed your sentence. This also applies to federal felonies for Medicare and Medicaid, but it also applies for situations where the provider may have been terminated from Florida Medicaid program or from other federal Medicaid program by the federal government. And in those cases, you simply are not eligible unless you have been reinstated and have been in good standing for 5 years. You also cannot be currently listed on the Office of Inspector General list of excluded entities. And obviously, if you have immigration issues, you probably will not be able to obtain licensure unless you have a social security number. Continuing education, you're here for that, so I'm not going to cover it. Prohibitions. So the Department of Health, as I said, is the entity that regulates the practice of medicine. They also enforce it. So that means that if you violate any of the Practice Act regulations, you may be subject to Department of Health investigation and possible prosecution. That means possible penalties on your license. Here I have a list of chapters that you might be interested in. There is a chapter of general applicability for all healthcare providers, and that is chapter 456 of the Florida statutes. But then there are also chapters that are specific to your particular license, whether you're a medical doctor or a DO. Prohibited acts are listed specifically. Hi, Ron. So the offenses are listed under these statutes. It's going to cover a variety of things that are disciplinary actions, but also anything that has to do with criminal offenses, whether felonies or misdemeanors. Most of these violations involve dishonesty. So you want to keep an eye on those things. Fraud and abuse is something that Ron will cover, so I'm not going to go over this, but fraud and abuse are things that are prohibited offenses that the Department of Health can prosecute you for. So you're not just going to be prosecuted by, Medicare, Medicaid, CMS, or that. The Department of Health will also get involved. It's kind of a trickling effect. Talking about impairment, this is something that I see a lot in licensing. It's one of the most popular reasons why people get in trouble. Being unable to practice with reasonable skill and safety is a violation of the Practice Act. And impairment is a legal term. Impairment means being unable to practice with reasonable skill and safety because of substance abuse issues, mental health issues, or physical disability. We see it most often with substance abuse problems, but it really covers mental health and also certain type of debilitating diseases that might make it hard for you to practice or actually be impaired. The Department of Health has created a impaired practitioner program, and that impaired practitioner program in the state of Florida is called the Professional Resource Network, PRN. Their website is down there too. They're the ones that act as agents for the department. They're consultants for the department. They connect providers with evaluators and treatment facilities and monitored impaired practitioners. We're calling this an impairment safe harbor. The reality is that the department can prosecute you for being impaired, but if you comply or enroll in an impaired practitioner program, such as PRN, and you comply with all of their terms, then the department will not investigate your license and will not prosecute you. That, of course, is assuming that you comply with all the terms for the entire duration of your relationship with PRN, and that could be up for 5 years. So you want to keep an eye on that. PRN might get involved too by board order. If you get in trouble, that could be a possible penalty that the board might impose, that you go to PRN. Sexual misconduct is also a violation. I'm sure you guys know that. If there's any takeaway from this, is just don't have sex with your patients. Nothing good comes from it. The fact of the matter is that patients cannot provide consent. So it doesn't matter if the patient asks you out or whatever the circumstances are, you simply can't do it. And you also probably should know that it covers patients' families and representatives as well. You know, you don't want to get into an affair with your patient's spouse. That's probably a bad idea. After all, your duty is to provide care to the patient and make sure that you do good by them. And that does not necessarily include just actually engaging in sexual activity, but also attempting to engage in sexual activity. Refusal to provide emergency care is also a violation. This probably will be more pertinent to those of you who work in facilities. Facilities also are covered by certain laws that require them to provide care in emergency situations, but you do not want to get into a situation where the Department of Health is investigating you for abandoning a patient. That's no bueno. So let's not do that. There are other prohibited acts here. I'm just going to go through some of these. Again, most of them have to do with honesty. Just try to be transparent. That means financially, don't falsely advertise. Don't break any type of rules and obligations that are applied to you by your facility, but also the department. And make sure that you're careful when dealing with family and friends. It's easy to get a little lax in those circumstances, but the laws still apply regardless of the circumstances. So another important one that I want to point out is that as a provider, you have a mandatory duty to report. That means reporting yourself if you've been convicted of a crime. That also means reporting practitioners or colleagues that you are aware have violated the Practice Act. So the complaints against physicians are things that are covered by the Department of Health. Billing disputes are not covered by the Department of Health. The stuff we just talked about is covered by the Department of Health. They will initiate an investigation, and investigations can last a long time. An investigation is not a formal charge, so that will not appear on your profile. If it's dismissed, then we're all happy and that's great, but dismissal is not guaranteed. If there's probable cause, the Department of Health will formally charge you with an administrative complaint. That will be public record, and the only way to get rid of that is if you are able to prove that the violations don't apply to you and get the case dismissed. Otherwise, it'll be on your record forever because it cannot be expunged. And that will be also given to the National Practitioners Data Bank. So there are serious consequences to any type of disciplinary violation. What are the possible penalties? The boards are the ultimate decision maker for penalties, so they have discretion. There are disciplinary guidelines that are listed in the Florida Administrative Code that kind of give a range for the board to follow, but the board has ultimate discretion. Obviously, the worst type of penalty is permanent revocation. That doesn't happen very often, but it happens in certain specific situations. Sexual misconduct is one of those things that will result in permanent revocation. Certain acts of fraud and abuse can result in permanent revocation. In fact, the disqualifying offenses that we talked about earlier when applying for licensure or licensure renewal, because they're disqualifying offenses for licensure, usually they will result in permanent revocation as well. Short of permanent revocation, you're dealing with suspension. As suspension means you cannot practice. The period is usually limited either by time or on the occurrence of some event. For example, you could be suspended on the condition that you comply with PRN. That's an example. Probation is lower from that, and probation is you're allowed to practice, but you need to be supervised. There are other conditions depending on what you do exactly, but generally speaking, it will require you to provide quarterly reports to the Department of Health, and it will require a supervisor to provide quarterly reports. That means that if you run your own clinic, you might be in trouble because you need somebody to supervise you there. So keep an eye on that. And then I also want to mention the letter of concern. A letter of concern is a letter that the department and the boards create and send to the National Practitioners Data Bank. That's what a letter of concern is. Obviously, it's not ideal, but you need to keep in mind that the National Practitioners Data Bank will already have flagged you for having an administrative complaint on your license. So that's something to consider. You also may be responsible for refunding fees or maybe continuing education classes, some type of corrective action, but you will always be responsible for administrative costs of the Department of Health, the cost that they incurred in prosecuting you. Yeah, these are some statutory penalties that you want to keep an eye on that are considered misdemeanors and some that are considered felonies. Meaning what? Meaning that if you get in trouble for one of these things, you're probably going to fight an action with the Department of Health, but also entities such as the police, the sheriff's office, the state attorney's office, and so forth. And here's some 10 golden rules. I'll keep this up here for a second. The most important thing is tell the truth. Again, you probably noticed a pattern. Most of these violations involve dishonesty or acts that put to question whether you behaved ethically. So you want to really ask yourself, are you behaving ethically? And that brings me to medical ethics. I don't know if Ron, you would like to take over and talk about fraud and abuse before we talk about ethics.
You continue.
What's that?
You can continue. I think I'm still muted by the operator.
Okay, I can hear you. But let's talk a little
You're
bit
good,
about.
Ron.
What's that?
Go ahead, Sarah. Go ahead and finish up. And then I'll come on.
What is ethics? Ethics is not something that is easily described. Really, it's a study that looks at behavior. So we're trying to figure out what ethics is. We know what ethics is not. Ethics is not the same as feelings. It's not religion. It's not following the law. It's not cultural norms, and it's not science. But ethics talks about moral principles, what's good and bad, what's right and wrong, and really looks at the practice of medicine specifically and how physicians like yourself operate in the medical industry. That is in relationships to the patient, but also to the public, okay? And medical ethicists have come up with 4 major principles for medical ethics, and that is autonomy, beneficence, non-malfeasance, and justice. And we'll cover all of those in just a second. So autonomy really applies to the patient, and that is the individual right to of every person to have authority over their life and choice over their bodies. So that's something that that covers and is paramount to the practice of medicine and medical ethics overall. Beneficence is pretty self-explanatory. You have to do good, and that is good to the medical community, to patients, but also each patient. Non-malfeasance goes back to the Hippocratic Oath. Above all else, do no harm. And justice is probably the one that is harder to explain, but and more technical. It really looks at how we distribute scarce resources amongst a high demand. That can think about, organ transplants or something like that. So how do ethical issues come up? They come up everywhere. You're going to encounter this on a daily basis in your practice. The common issues are usually end of care, how to distribute limited resources, issues between decisions for treatment and limited finances. But in the world of today, with the advent of technology, I also wanted to point out a couple of them that come up, and that is the ethical use of big data. With the use of electronic medical records, we're capable of such information and use that information for the greater good and innovation, but you also have to balance that with the individual privacy interests of the patient. Also, the ethical use of AI. We use AI a lot. I see it a lot in radiology, for example, and the question is, are we using that ethically and responsibly? And then finally, probably most apt is, how do we respond to global pandemics? So let's talk a little bit about COVID-19. These are typical ethical questions that apply to medicine. Does public safety supersede an individual's right to wear a mask? Now that we have a vaccine, should everybody get vaccinated? Should children get vaccinated before they return to school? What about resources and the scarcity of resources? Should COVID patients have precedence over other types of patients when it comes to limited ICU beds or ventilators? These are all things that we should take into consideration that are part of ethical dilemmas, and it requires a thought process. That's really what ethics is about. So first and foremost, you must remember and must consider, what is the dilemma in the first place? Once you've identified that, ask yourself, what is your role? And if in that role, do you owe a duty? And what is that duty exactly? Who do you owe a duty to? When trying to approach these type of ethical dilemmas, you always have to consider these questions, consider your behavior, and consider the motivation behind your behavior. So here are some ethical principles to remember. I added some information here. Always consider veracity. That means tell the truth, always tell the truth, and fidelity. Be honest and be faithful to your duty as a physician. So I have some scenarios here. We're going to go over a few. We don't have time for all of them. So let's look at this one. Mrs. L is a 40-year-old woman with bipolar disorder, with paranoid delusions and suicidal ideation. You've worked with her before, and in your most recent visit, she tells you that she's stopped taking her medications because she feels fine, and she's decided that she's just not going to take her meds and instead do a lot of physical exercise. Sounds all good. You know, though, however, that she's had paranoid delusions before. You know that she's a teacher, so she works with children, and you know that she lives with her mother. What do? Do you tell her mother? Do you call her and make sure that her mother makes her take her meds? Do you call her employer, and do you ask her employer to keep an eye on her because you're afraid for this children's safety? Another scenario here. Let's say that you're the family physician for Mr. and Mrs. K, and Mr. K comes to your office seeking STD testing specifically for HIV, and unfortunately, he is positive for HIV. The week later, Mrs. K shows up to your office. She's there for a regular visit. What do? Do you suggest that she should get an HIV test? Do you do it without disclosing why she should get an HIV test? So confidentiality and privilege is part of a principle of autonomy, if you think about it, but obviously privilege is very, very important in medicine. There are circumstances, though, where disclosure is permitted by law. And so while we're not talking about law specifically, as a lawyer, I'm bound to tell you that the law does require disclosure in some circumstances. Now, sexually transmitted disease information and mental health information is very much protected by state and federal law, even more so than other types of medical information, but you should look at that. So talking about the Baker Act, for example, you have that avenue available to you. The Baker Act is mostly famous for involuntary evaluations. That's what we're talking about. So in terms of our hypothetical scenario, do you think that your patient is a danger to herself and others such that she should be Baker Acted? That's a question. Regarding sexually transmitted diseases, there actually is a requirement that you report people who are positive for HIV. Different is the question as to whether you should disclose that information to their spouse. Here's another hypothetical scenario is HIPAA in the office. So you have this new office manager and there are questions as to whether you are compliant. Can you call patients by name in the waiting room? Can you leave appointment reminders or information on a patient's voicemail? Can you communicate to their spouse? Again, you want to respect the confidentiality of the patient, but not all disclosures are prohibited. Incidental disclosures are part of the practice, and so long as you are applying reasonable safeguards, then you should be fine. Let's talk about, okay, discharging difficult patients. This is something that comes up. So let's say that you have a patient that has some pretty significant conditions and maybe she doesn't show up to your office appointments and now all of a sudden she wants to see you. She shows up at the office, she's abusive. How do you handle that? Can you legitimately discharge it? Well, the risk of discharging a difficult patient always comes to, is the patient taken care of? You can't just abandon a patient. So there are concerns from an ethical standpoint, but also a legal standpoint. If there's an urgent situation and an emergency situation, you cannot just abandon the patient. You will be prosecuted for that. If there's no access to another physician that can take care of them, that's also a problem. If it would compromise the patient's health, that would be a problem. You need to follow appropriate steps, and those appropriate steps include documentation. So you need to first, of course, try to resolve the conflict, make sure that you have records and copies of everything before discharging a patient, and make sure that they have continuity of care. Let's talk about impaired physicians. This applies, this happens unfortunately frequently. As I said earlier, the law says you have a mandatory duty to report. The question is, do you have an ethical duty to report? If you have a colleague that you suspect is impaired, what do? You have to report them technically because you are responsible for protecting patients from impaired practitioners and the law says so. But our advice is when dealing with a colleague, try to have an informal intervention, talk to the colleague, try to help them. Again, the professional resource network is something that they should look into. Maybe advise them to contact an attorney, but before reporting, that's something you should do, but keep in mind as to your legal duties as well.